So what I wanted to start with is to draw your attention perhaps to the fact that data protection and privacy are not the same thing. The GDPR is strictly about data protection. Privacy is a somewhat related concept, but it's not exactly the same thing. Privacy is protected by a wide range of rules in the Napoleonic Code, so in France and in the countries that adopted similar civil codes inspired by the Napoleonic Code. There is a special provision in the civil code that protects privacy. But when you think about it, data protection rules are about protecting information about the person, and this information does not necessarily have to refer to the private sphere of life of the individual. So the fact that someone is a researcher at Institut für Deutsche Sprache in Mannheim, like me, it is not private information because it refers to the public sphere of my activities, but it's nonetheless personal data. And vice versa, you can violate one's privacy without processing any information about him, for example, simply by knocking at his or her door or entering his or her apartment uninvited. I hear it a lot. The GDPR is about data privacy, GDPR is about privacy. And this is not exactly the case. So for today, I would like us to set privacy aside and focus on data protection, really the processing of information that relates to living individuals. And Walter, perhaps you'll tell us something about the GDPR. What's this? What is it?
Yeah, exactly. Hi, I'm Walter. Pavel and Vanessa have already introduced me to you, so I'll pick right up. We were already mentioning the GDPR a couple of times. GDPR translates to General Data Protection Regulation, and it was passed as a regulation of the European Union in April 2016 and has been in force as of May 25, 2018. Now, the important thing about a regulation versus a directive is that a regulation actually becomes directly applicable and enforceable law in the European Union and the European Economic Area when it takes effect, so in this case 2018. Whereas a directive is a legal act of the European Union, which still requires member states to achieve the results that are pointed out in the directive without dictating the means of achieving it. So basically, there is a lot more leeway, there is a lot more flexibility for member states regarding a directive, because they have to take the directive and then implement it in their national legislation. Now, having said that, of course, also with a regulation, there are certain things that need to be implemented in the national data protection acts. And there have been amendments in pretty much every European country since then. Pavel will probably know more about these details. The important thing about the GDPR legislation is that it is not retroactive. So it does not apply on any processing of data, because that's what it's all about. That happened before May 25, 2018. It does, however, apply to data processing ever since, even if the data was collected before that date. So that's very important, but it is not retroactive. Apart from clearing what the GDPR actually means, or General Data Protection Regulation means, there are a number of basic concepts which we want to introduce to you. So the first one is probably switching back to Pavel about what it is all about. So what do we mean when we talk about personal data and processing, actually? Because that's what the GDPR is.
The GDPR is all about the processing of personal data. So what is personal data? Personal data is any information about an identifiable, about an identified or identifiable natural person. So this information can be split into a number of elements. First of all, it's any information. So regardless of its form, whether it's analog or digital, whether it's video, audio, text, so something written on a piece of paper can be personal data, and the digital information in a digital file can be personal data as well. But also from this any information element, you can get that it's personal information is protected regardless of its content. So no matter if it's a fact or an opinion, or whether it's true or false, if someone writes something that is false about a living individual, it's still personal data. If someone writes an opinion about a living intellectual, a living individual that is not necessarily true, it's still personal data. Now, this personal data has to relate to an identified or identifiable person. A person is identified if it's singled out from a group as this one, this fellow there, or identifiable if it is possible to identify either via a name or an ID number, or by a unique combination of various elements. When you think about it, most names, or even most names and surnames, are not directly identifiable because there are several persons with the same name and surname. So you need extra information. You need date of birth. You need hometown to really identify, single out the person. And this can be any information, any combination of such elements. So, for instance, if you have a speaker or a translator of a under-resourced language, a language that has very few speakers and even fewer translators, who lives in Berlin, for example, that in itself can be enough to identify the person, because there is only one translator of this language in Berlin. And then the definition also contains this natural person element. What's a natural person? Well, a natural person is a legal way of saying a living individual. So there's no personal data for companies, and there is normally no data protection for the deceased, although there might be some special rules about that in some member states. France famously has a framework for protecting data of the deceased. And this is increasingly something that member states will address with social media and what to do with information in social media after the death of the person. Yes, so also an information about a dead person can refer to its family who is still alive, his or her family members. For example, information that a person died of a rare disease may have an impact on how the family members are treated with regards to, for example, capacity to get credit, etc. Now, that is a complex definition, arguably, but it is really very, very broad. Processing is also very broad, and it's simpler. Processing is anything you can do with data, and that includes storage, and that includes erasure, that includes anonymization. It's really anything you do with the data. And the person that data relates to, this living individual I mentioned, is called a data subject. And I leave the floor to Walter for the definition of the data subject and other stakeholders in data processing.
Yes, indeed. So now that we've learned about personal data, so what is personal data and what is processing, which is pretty much everything you can think of doing with that kind of data. The other thing is to clear the roles that are defined in the GDPR. We're going to look some more at the principles of the GDPR, also of the rights of individuals under the framework of the GDPR in a couple of minutes. So it's important to know the lingo that is involved with the whole thing. And that also refers to the roles that are defined in this legal text. So basically, there are 3 different roles that are differentiated based on the placement of the individual in the data processing, basically. So the data subject, starting with the most personal thing, because data subject is basically what we are all the time whenever our data is processed, is the identified or identifiable natural person. Pavel already explained that concept, whose data is being processed. So the subject that the data refers to, which, as I said, is us for the most part in many operations. But very often, especially in a research context, we would also be, well, at least partially the controller. Having said that, the controller is the party that determines both the purpose and the means of the data processing. That can be a natural person. It can also be a legal person. It might be a public authority or some other body. So also this role can be held by more than one party, and we speak of joint controllers. In the most common research settings, usually we are, as individual researchers, employed by a research institution or a cultural heritage institution. And this institution will be the controller, since they are actually our boss. And usually this is dealt with by the institutions. As an individual researcher who conducts their own surveys, you might as well be the controller of the data you process if there is no institution behind it. So in my case, for example, if I collect your data for attending this workshop, the University of Graz, as my employer and as the one who basically pays for me to do these workshops, would be the controller of that data. Then the second role, or the intermediate between these roles, the controller and the data subject, is the processor. That's a natural legal person, again, authority, agency, etc., which processes personal data on behalf of the controller. Which also means that this role is not always filled. Sometimes in the data processing of personal data situation, you will only have a controller and the data subject. But as soon as any operations are outsourced, basically, there is a processor in place who conducts these operations on behalf of the controller, which has certain repercussions on responsibilities and stuff like that. But since this is a workshop on us as researchers or as data subjects and not about data protection officers, we will not cover that in any length because that's a very different workshop then. Yeah, so we have talked about natural persons, about identified and identifiable persons, which is the gist of processing of personal data. But what are ways to actually deal with this identification or to circumvent the identification and therefore solve some problems that we have with the data processing covered? You're still mute, Pavel.
Nice, that's something.
Thank you. Thank you. Thank you.
We had that.
That's a very good mean of anonymizing, actually, turning the mic off. Especially if there is no video and no name. Anyways, thank you, Walter, for bringing these two issues together. It's a very good point. Indeed, the notion of anonymization, which is a key notion in data protection, is very closely related to the very definition of personal data. You remember when I said that personal data is any information related to a person. Now, the key is in the word related. Now, I mean, how the information relates to a person. Well, an information relates to a person if this person can be identified by means reasonably likely to be used, not by any means, because, well, come to think of it, everyone can be identifiable by someone somewhere using some means, right? It has to be by means reasonably likely to be used. So if you have a data set and you are wondering whether the persons that the data refer to are identifiable or not, so whether your data set is to be considered as personal data or not, the question you have to ask yourself is it possible to identify those persons by reasonable means? Okay, and please note that with technological progress, this catalog of reasonable means is getting larger and larger, because perhaps soon we will have apps in our smartphones. Everyone will have apps for biometric identification, and you'll just take a picture of someone and you will get his personal website or his Facebook website. This is not entirely impossible. But anyways, anonymization consists of breaking the link between the data and the person, so that the person is no longer identifiable by reasonable means. All right, and data that is anonymized properly is no longer to be considered personal data, and therefore is completely free from any GDPR related constraints. Anonymized data can be processed freely without respecting the GDPR at all. Pseudonymization, however, is something completely different. Well, very different, not completely different. Pseudonymization consists of replacing the identifying elements in the data set, typically names and surnames, with identifiers. So, for instance, subject A, or false names. You give someone a false name, you call him Peter because you like the name Peter in your data set. And then you retain the information that, in fact, Peter or subject A is Walter Scholger in your data set, and you keep this information separately in a secure environment. For instance, only on the PI's computer, and all the annotators, all the student assistants, they can only see the pseudonymized data set. This is pseudonymization. Pseudonymized data are still to be considered personal data, because the information necessary to identify the person still exists, and it is not impossible to re-identify the person. However, pseudonymization can be regarded, especially in the research context, as an appropriate safeguard. And appropriate safeguards are something of crucial importance for research under the GDPR. Walter, will you tell us more about appropriate safeguards?
Yes, actually. So we will look into rights defined for the data subject, and also obligations or principles actually of data processing in a few minutes. But especially in the context of this workshop and the tool that we have developed, it's important to remember that there are certain provisions, privileges, and exceptions made under the GDPR for research and similar purposes. So there are academic exceptions, and I put that in air quotes, from the controller's obligations and the data subject's rights, that where these are likely to render impossible or seriously impair the achievement of the specific purpose. That's a quote from the Article 89 of the GDPR. Article 89, you will find out, is the flagship of academic exceptions. That's basically the article that we can base a lot of exceptions to the data protection regulation on. And it defines exceptions for archiving purposes in the public interest, for scientific or historical research purposes, or for statistical purposes. Now, I, being a historian, always wonder why there is a distinction between scientific and historical research purposes, but that's just a side note. And we will look at that in some more detail. Now, these privileges, they provide us with certain advantages that a non-academic setting cannot make use of, which are very helpful, and we're going to look at that more. But all of them require appropriate safeguards, which is the term for it, to be in place. And such appropriate safeguards can be technical or organizational measures. They can be ethical measures, actually, which tie very closely into that. So it might be, for example, the pseudonymization of data, as Pavel already pointed out. It might be the adherence to a code of conduct, which is predefined and communicated to the data subjects. It might be other measures of security for the data and for the proper use of that data. So there's a fairly large, like these appropriate safeguards are not really defined, closely defined. So there is some leeway to it, but the important thing is that even if we are allowed to process personal data for these purposes, research, archiving, statistical purposes, that means we still have to act responsibly with it. So it doesn't take the responsibility for the data and for the processing from us, but to the very contrary, it just encourages us, and not just encourages, but requires us to be extra careful about these things and to care for appropriate safeguards for this data.
Yes, if I may, Walter, I think it's important to mention that the appropriateness of the safeguards, so to say, is depends on the specific case. So you really cannot decide a priori. What you need to do is you have to kind of have a general conception of how you're gonna process personal data in your project, identify the interests and rights of data subject that can be in danger, and think about the safeguards that can be introduced to mitigate the risks for data subjects. And it can really vary from staff training. You will only give the data to researchers who have attended this workshop, for example, or have received some basic training in GDPR issues. And it can be very, very advanced if you're working on really sensitive data. It can be state-of-the-art data encryption, so that you know, and no researcher will really see the whole data set. They only see bits and pieces that will be encrypted, and so the rest will be encrypted, and they only see tiny little bits, like in a dystopian movie. So we only get little bits and pieces of information, and we don't really get the whole picture. This is a possibility as well. And what these appropriate safeguards give you, they give you a lot. They give you access to exceptions for research, exceptions chiefly from the general principles that we will talk about right now. Can you please move to the next slide? Yes, so these are the general principles of data protection in the GDPR. In Article 5, this is the heart of the GDPR. If you can only read one article in the GDPR, make it Article 5. It lists a number of principles that apply to data processing. The first of those principles is called lawfulness. Lawfulness means that in order to comply with the GDPR, processing has to have a legal basis. So legal basis, the available legal bases are listed in Article 6. There's quite a number of them, but those that are most commonly used in research are consent and legitimate interest or public interest. Now you have, I'm sorry, you have all heard, it's a phone, home office. You have all heard about consent, and I think many people still believe that consent is always necessary to process personal data under the GDPR. Well, this is actually not true. There are alternatives to consent, but consent is, at least in my community, in the German community, and in Walter's community, from what I know, in the Austrian community, it should be the go-to legal basis for your processing. Now, what is consent? Consent is a declaration from the data subject by which he declares his consent for data processing, and in order to be valid, this consent has to be freely given, specific, informed, and unambiguous. Without entering very much into details, because we are kind of running out of time already, please note that consent has to be informed, which means that a certain number of information about the processing should be given to the data subject to make his consent valid. Before consenting, before giving consent, the data subject should know what he consents for. This is why you need a consent form, and this is what the consent form wizard helps you with. And if you think that consent is not possible to collect or not practical to collect, you can rely on alternative legal basis like legitimate interest, or in some countries, public interest. The difference between the two is quite important. Legitimate interest relies on a simple balance of interest between your interest as a researcher and your community, and the benefits that your research can produce for your community, and the interest of the data subject. Now, so you simply have to make an analysis of what's more important, my research or the interest of the data subject in protecting his personal data. Public interest is different because there is no balancing test, and it is simply based on legal provision that is set in the law. Now, in most countries, public interest, I think, is not really available for research. At least in my community, we are not using public interest as a legal basis, but legitimate interest by all means. So if you cannot, all this to say that if you cannot collect consent, it doesn't mean that you cannot process personal data. You still can, but you have to rely on a different legal ground. All right. So I'll give the floor to Walter for fairness and transparency.
Yeah, closely tied with the lawfulness is the principle of fairness and transparency. It's actually on the same paragraph, basically. So fairly, on one hand, means what you would expect it to mean. Fairness is data has to be processed in good faith. So both the data subject can reasonably expect you to not abuse their data, essentially, or to use their data fairly. Transparency is more closely defined. Transparent manner in relation to the data subject means that any information and communication relating to the processing of personal data must be, on one hand, easily accessible and also easy to understand. So, for example, that clear and plain language is used, which is often a problem in legal contexts, probably, if you have dealt with such things before, that legal language is very often inaccessible to those who have not encountered it before. And in this case, the provision for transparency calls for clear and easy language, which any data subject can understand. The identity of the controller, we heard about the role before, and also the purposes of the processing must be clearly communicated, as well as any risks to the data processing, rules, safeguards, and rights in relation to the process. processing. So there has to be a very clear communication about that, and that will come back to us in a few minutes when we talk about the right to information. When we talk about the purposes of the processing, there's some more stuff to take care of, and that's something that Pavel will explain now.
So another principle is purpose limitation. This is very important. It says that data, personal data, can only be processed for a clearly defined purpose and not further processed for an incompatible purpose. So if you process personal data, you have to know why. However, there is an exception for research with appropriate safeguards. If you process data for research purposes or for archiving purposes with appropriate safeguards, then you can reuse data that were collected for other purposes. Why? Because there is a specific provision in the GDPR that says that research and archiving are not incompatible with any other purpose. So even if it was collected for marketing purposes or for the purposes of opening a bank account, research and archiving are not incompatible. So as researchers, you're not really limited very much by purpose limitation, but in order to have access to this extension of purpose, you need to apply appropriate safeguards, and you have to address this repurposing of data in your appropriate safeguards. All right.
Yeah, which brings us to data minimization, which is a fairly easy principle to relate to probably, and that means that the data collection and processing must be limited to what is necessary in relation to the purposes for which the data are processed. You will probably have encountered cookies a lot of late, which ask you for consent to using various cookies to record all sorts of stuff when you enter a website. Most of these are actually done not entirely right, but that's another piece. So basically what this is about is only collect the data that you actually need for your purpose and not more than that. So if we need you to register for a workshop, for example, and especially if you are in the online audience, we have no business asking you for dietary requirements because you will not be joining us for coffee, unfortunately. So obviously we shouldn't ask you about that. So obviously just even at the collection stage, you should have appropriate safeguards in place, measures in place, which refers to data protection by design and by default as well, that you're not even like that you're not even able to collect data that is of no business for the purpose that you're processing it with, which is closely tied to storage limitation. But first, let's have a look at accuracy.
Yes, accuracy is a simple principle that is not very important for research because it's kind of embedded in research ethics. So according to the accuracy principle, personal data should be accurate, and if they are not accurate, they should be rectified. So if you have a typo in someone's name, if you have somebody's address wrong in your database, then you have to rectify it or give the data subject a possibility to rectify it. Of course, researchers have those who look for the truth, of course, that is all researchers have no business in processing inaccurate data. So naturally, researchers care about accuracy. Storage limitation is a bigger principle, and it's something that causes much wailing and gnashing of teeth among researchers when I tell them that personal data can only be stored for a limited period of time. You cannot store personal data forever, and this period of time has to be limited to what is necessary for achieving the purpose of the processing. Typically, if you are in a newsletter, if you are a member of a newsletter, or you have an account on in a website, and now if you are not using it, you haven't used the website, you haven't used your account for, I don't know, depending on the website, 2-3 years, you will receive an email telling you that if you don't use it, then it will be deleted, because this is the legal obligation now. They cannot keep your login data forever. However, don't worry. In the context of research and archiving, with appropriate safeguards, once again, personal data can be stored for longer than necessary. It doesn't really mean that they can be stored forever, but you are no longer restricted to what is strictly necessary for your research. You can also keep it for, I don't know, let's say 10, 15, 20 years after the end of your research. And then it doesn't necessarily mean that you have to delete your the personal data or anonymize the personal data after this period, but at least you should have a thorough review whether the personal data still complies with data protection principles, because you know, with technology that is evolving, the standards of data protection evolve as well. Bottom line, in research and archiving, you can keep personal data for longer than necessary, and you don't have to worry that much about storage limitation, even though you should try and put a number of years on the number of years for which you will keep the data. Now, there is a principle of integrity and confidentiality, also known as security, but it's a technical principle rather than a legal one. Basically, you should make efforts to protect your data from unauthorized access, accidental deletion, loss of, what is it called? Well, I don't know, because I'm not a technical person. So you should have ideally backup copies, so you don't accidentally lose it. You should consider having password protection, so it's protected against unauthorized access, etc., etc. But these are technical rather than legal issues, so we won't talk about it much, even though it is very important. And then there comes accountability, Walter, your favorite one.
Not entirely. So basically, just to pick up briefly on the question that Daria posted in chat, or the observation that data minimization gets in the way of, or that, yeah, that the research exception basically gets in the way with data minimization. That is true to some extent. But that means data minimization is always in place. So we cannot just collect any data at the point where we are collecting data. That just means that if we have collected data lawfully and for another purpose, we can then reuse it in a research context. But we're not allowed to basically just collect any old data that we might be interested in the future, because we're still bound by data minimization and by the purpose limitation. But as Pavel pointed out before, in the research context or archiving context, we can then get back to that data that we lawfully collected for a different context and then reuse it in the research context, because research is always a compatible purpose. But that doesn't mean that we can basically dispense with the data minimization in the first place. So accountability is, again, something that is primarily important for data protection officers, I guess. Because it means that we have to record data processing activities, we have to make an impact assessment of risks that can occur with the data processing that we are doing. But since this is actually something that should be done by the data protection officers of the institutions that were so kind to hire us, we don't need to worry about it too much in the context of this workshop. But it's important to keep in mind that obviously this accountability and responsibility for the data that we are processing is a very important thing to take care of, even if someone else usually does that for us, who is the data protection officer of our institution. Can we skip to the next slide, please?
So now come the rights of data subjects, and we unfortunately won't have time to enter into much detail about all of them. Let me just tell you that for our purposes, for purposes of our consent form wizard, information was by far the most important right of the data subject, and we have a special slide on this. And there are other rights like access or rectification, that is about giving the data subject the possibility to well, simply access personal data about him that are being processed. This also enhances transparency, because you remember the principle of transparency. So indeed, the processing of personal data ideally should be transparent. There is rectification that is related to accuracy. There is data portability, an interesting right that allows the data subject to request his data, a copy of his data in a reusable format so that he can transfer it to another service provider, for example. Not very important for research, but think about online streaming services. You want to change the provider from, I don't know, Spotify to Amazon Music. So you can ask Spotify your whole history in a commonly reusable format, so you can give it to Amazon, and Amazon can have your history so that they can suggest music that you are likely to like. This is what portability is about. Now, erasure, the right to be forgotten, allows the data subject to have his data deleted, but only in some very, very limited circumstances, especially if it's unlawfully processed, if one of the principles is violated. Restriction of processing, also known as blocking, is kind of similar to erasure, although the data is not deleted, but just blocked, so it cannot be processed without consent of the data subject during a period of time. Also to be used only in very limited circumstances. And there is the right to object. Now you remember, I actually haven't said about that, and that's very important. Consent can always be withdrawn. So if your the processing of your personal data is based on consent, data subject can always withdraw his consent. All right, and if you decide instead to choose legitimate interest as the basis for your processing, then the data subject has the right to object. So he can, he or she can put in question the analysis that you've made and say that actually, well, your purposes, my interests in the protection of this particular data set are actually bigger than your interest in the processing. So this is objection. However, all these rights are very heavily limited when it comes to archiving and academic research, especially if the exercise of these rights can seriously impair the purposes for which the data were processed. If you are interested in the rights of data subject, we, as Clarin and the Clarin Legal and Ethical Issues Committee, organized an event about the rights of data subject in language resources specifically in March 2021, and the event was recorded, so we can still see it, but I will spoil it for you a little bit. The conclusion is that in research and archiving purposes, there is very, very little left from the rights of data subjects. All right, can you please move to the next slide? So you remember I mentioned information to be provided to data subject, the right of information. And this is really what our consent form wizard is all about. This is a list, these bullet points quite complicated. This is a list of very simplified list of information that has to be provided to the data subject in order for processing to be lawful. And this is regardless of whether the data is collected from the data subject or from a different source. So if you download data from the internet about someone, you still have to inform this person that you process his or her data. You still have to inform him or her about your identity, your purpose, the legal basis, the retention period, etc., etc. No matter if the processing is based on consent or not. But in order to be able to have all this information handy, you can use the consent form wizard. Now, you might be interested in the fact that there are indeed exceptions from this right of information for research purposes, but they are not that easily available, the exception. So, for example, this information does not have to be provided if the data were not collected directly from the data subject, but from another source, and providing information to the data subject would require disproportionate effort. And there is a 3-step test for disproportionate effort that I won't tell you about, but it's quite strict. For example, if you download data from social media, from LinkedIn, for example, or from Facebook, there is, even if you download millions of profiles, and informing all those persons will take forever, there is still no impossibility. Why? Because social media services, by definition, enable you to contact the person quite easily. All right, so you cannot argue disproportionate effort in contacting those persons. You can argue disproportionate effort if you find an old data set somewhere in the library and you don't know if the data subjects are still alive or not. You don't know where they live. You don't, especially if the data is old and there are very many data subjects, then you can rely on disproportionate effort and ignore the information to provide information. But otherwise, you always have to provide information. And this is what the consent form wizard can help you with. All right. Do you have anything to add, Walter? You are muted, by the way.
No, I'm having the room microphone, so that's why my personal one is muted. Yeah, I think that's pretty much it. That was the crash course through the GDPR. You can find some more information about that. There has been a handout that Pavel has prepared for a different context, which is very helpful for research and archiving questions regarding the GDPR. You have the link here on the slide. If you want to look at the GDPR in more detail, you can use the other link on that page. It's actually very well done. You can also see the various, not just the various articles, but actually also the thoughts that went into these articles to explain a lot more about how they came to these decisions. Of course, if there are any questions, you can always contact either us at ELDAH or Pavel directly. And you can also check out some of the learning materials and presentations that we've done. You can find those on the ELDAH website. There's also a tutorial on basic concepts of the GDPR and using the ELDAH consent form wizard on our YouTube channel in both English and German. Which will cover a lot of ground that we also cover in this workshop. It's a video tutorial, so you can find more information there. yeah, I think that's pretty much it for the introduction to the GDPR for now. I'll just have a look at the chat briefly if there are any more questions. I see shaking heads. There is one thing by Tiomir that I will comment on in the chat in a second. And otherwise, I think we are set for a coffee break.
Yes. Yeah, sure. We are already ahead of our schedule, but we will start the next session at 11:15. So we will just postpone a little bit the starting of the new session. We will have the group discussions then, but first we will all join the event online and here in the room, and then we will divide ourselves into 3 or maximum 4 groups. But you will have at least 20 minutes for taking a break, drink a coffee, and rest a little bit. Okay, so
thank you.
Over with this one. Okay, so now we will have a little pause break, coffee break. So see you in 11:15 for the next round. Okay. See you later. Bye.
Okay, so welcome back, everyone. Thanks for rejoining us. We're happy to see all of you in the physical, or almost all of you in the physical conference coming back, and also a lot of you in the virtual format. So that's nice to see. We are moving to the hands-on part of this workshop. Well, we have had some quite intense practical discussion already. And we managed to identify all the issues and all the problems that we have when it comes to data privacy. So now let's move on and learn about the solutions. We have established that one appropriate way to handle personal data for research purposes lawfully is to collect consent from participants in research activities from whom data is collected, but also from participants who participate in other research affiliated activities. And for all of these contexts, we might need to collect consent, and for collecting consent, we might need a consent form. I'm sorry, I'm getting a little irritated because Zoom is screaming a lot of things at me, but I think now I'm fine. Okay, so we have established that we might need consent forms, but coming up with a proper consent form that fulfills all the legal requirements is a fairly legally complex thing to do, and not every individual and not even every institution has the capacities to come up with proper consent forms. So what to do, thought the Ethics and Legality in Digital Arts and Humanities working group of the research infrastructure DARIAH, and came up with a solution. How about we build a little tool to solve this problem? So this is how the DARIAH-HR consent form wizard was born, and we are looking at it right now. A little bit of context about the consent form wizard. It was chiefly developed by Walter and Pavel and myself, working together with Norbert Ciriak, a programmer at the Austrian Academy of Sciences, who implemented all the legal knowledge into a nifty little tool that works quite well. And one thing, while I'm introducing this nice little tool right now, that I realize we forgot, is that when it was translated, which it has been by now to 3 other languages than English, we somehow never noted down who did the translations. So here's one thing to put on our to-do list. We are going to find a proper page to note down credits, because the tool was originally developed in English, because our plan was to come up with a tool that can be used in all of the European Union. And since English is the de facto lingua franca, despite any English-speaking countries being members of the European Union, we decided to come up with an English tool in the beginning. But since the consent form wizard has been around for a little while now, I think over 2 years, we have in the first workshops that we did presenting this tool realized that many researchers actually would need a tool like that in their own national language, not because the researchers themselves do not understand the English tool, they do, but one very practical thing that we also discussed in the on-site group discussion in the morning session, even if the researchers are very comfortable with English and even with English legal lingo, which frankly not even I'm completely comfortable with, the research subjects might not be as comfortable in signing any sort of legal paperwork at all. And then if it's not even in their native language, then it becomes really uncomfortable for them. So that is actually one of the main motivations why we decided to translate the consent form wizard into, well, into all languages where we could find a translator. And we've been quite successful, I would say. And as you can see, you can see it up here in the top area over here, where you can switch the language. So by now we have implemented 4 different languages, and there are more to come. So, and if your native language or the language of the country where you work is not here yet, get in touch with us and offer us a translation. We are happy to accept whatever you can bring. Actually, one more thing about the translation of the wizard. Also, one more round of credits to Norbert, our programmer. He has actually implemented a very neat interface for translating this tool into other languages, which is also, I think, a topic that will become more and more important and popular in the DH overall. Okay, so enough of the introduction talk. Let's get down to business and look at what the consent form wizard does. On the introduction start page, you have some explanations about what the tool is and what it is not. So this is supposed to give a little bit of context, and you can see in this in this big type in the center that the consent form wizard hopes to help researchers to obtain consent forms in a fairly low-level way, but this cannot replace proper legal advisement if you feel that there is anything there are any legal aspects to your work that need any sort of discussion. So this tool does not replace a lawyer, but it can aid you in in doing research a little more lawfully, a little more ethically than would be possible for you if you had no resources at all to come up with such a thing such as a consent form. So the idea behind the tool is that you go through a questionnaire where you answer a number of questions about what you are planning to do, what kind of data you're collecting and what you're collecting it for. And then after you will have answered all the questions in the questionnaire, the tool spits out a consent form, which you can then take and hand over to the data subjects that you would like to, well, to the subjects that you would like to collect data from. And that is basically what this start page explains. Also, since we're actually processing data that you will be entering into the tool, we have to collect your consent for actually processing your data, which is what so you have to give your consent, and that is what you do by clicking enter here. In the first step, you have to choose a scenario that you are using the consent form wizard for. So you might do academic activities such as keeping in touch with other researchers, and you might be using a mailing list or other communication media for that. And if you would like to collect consent from the subscribers of your mailing lists or from similar areas, you have one scenario that you can go through with the wizard, where you will actually have a consent form for mailing list subscribers to consent to the use of their data for being informed about your research activities. You could also be hosting an academic event. You could be hosting it on Zoom, or you could be hosting it in real life, or you could even be doing a hybrid event. All these things are possible these days. And in any case, you will probably collect more or less data about the people who participate in this event. In order for you to be allowed to process these data, you will have to collect their consent. And if you actually want to do that, you can also use the consent form wizard for coming up with this. But since we did a little survey at the beginning of this day asking you from what areas of work you come, and most of you said that you came from the realm of research, we will look into the first and probably most prominent and most desired scenario that we developed for the consent form wizard, which is coming up with a consent form for gathering data from people, living people, for research purposes. So this is actually the main objective of the wizard, to help you come up with a consent form that you can give to your research subjects. We talked this morning a lot about oral history, and also I think one prominent topic we can consider is a collection of language data for linguistic research and such. So this is actually the main scenario that the consent form wizard is treating, and this is also what we're going to look into in practice now. You can, if you like, follow what I'm saying on your own screen by following the steps in your own wizard, maybe in your own language, but you don't have to do that because you are going to have some time to test the tool hands-on later yourself. So I will just start going through the wizard. So we are choosing our first scenario. We want to gather data from living people for research purposes. And the first question that you will have to answer is in what way you're planning to collect the data. You might be doing an online survey with your participants, or you could hand out more retro, a written survey and ask questions that people will have to answer on a piece of paper. You might be doing oral interviews or even video interviews with people. That is, of course, the oral history scenario, but not only that. Or you might be doing an oral interview and you might be recording that, but you might be throwing away the recording and only keeping the transcription. So let's say in our scenario, we're doing oral interviews and recording the sound. The next question that we have to answer is what type of data we are collecting from the people that we're interviewing. You can see that for this second question, we have a little remark here, which says that you are supposed to be aware that the GDPR requires you to minimize the personal data that is collected to only what is absolutely necessary for the purpose of that you're pursuing. Of course, when you're researching, the purpose that you're pursuing is relatively broad. So I think you wouldn't have to worry so much about the amount of data that you are collecting. But if you were to organize an academic event, that would be a different story. We mentioned this morning that we do not have any business recording information about dietary requirements of people who participate in an online conference, because, well, we're not sending you sweets. If we were, that would be a different story, of course. So for our hypothetical research purpose, let's say we are collecting, we said we're doing an oral interview. So we are probably not collecting IP addresses of our participants, but we will probably be collecting name and surname of our participants. We will be collecting their age, let's say their educational background, and maybe also their email addresses. Now, we have these fairly normal types of data categories that we will be that we might be recording, but there are also more sensitive data categories. There are actually sensitive data are explicitly defined in the GDPR, and they have to be treated in a different way than normal personal data. Among these are, for instance, information about ethnic origin of people, about their political opinions, about data that concern their health. So this is also why we like the example with the dietary requirements, because dietary requirements could actually provide some sort of indication about some medical status, but they might also provide an indication about some sort of religious belief system. So if your dietary requirement is that your food has to be kosher or halal, this might be an indication about your religious beliefs. And that would make it sensitive data and not just regular data. So let's say we are collecting information about our data subjects' sex life or sexual orientation, because that might be connected to the topic of our research. In that case, different requirements apply to the safeguarding of the data, so our consent form will change accordingly. We could also indicate other data categories which we could write into this field if we included more types of data. Of course, you're not allowed to enter any types of sensitive data into this other field, because we wouldn't be able to actually tell. And if you didn't choose any of the sensitive data categories, but entered them instead in the other field, then the consent form that the tool spits out would not actually consider that you are collecting sensitive data, and ergo it wouldn't be valid. The next question you have to answer is if you are going to be collecting information about third persons. So you might actually ask people about their grandparents for some reason in your research interview. So if these third people that you're collecting data about are identifiable and alive, then you would be operating in a very sensitive area of data privacy, and we would not advise you to use a standardized consent form to process the data that you're collecting. Therefore, you would be running into a dead end here in the tool, and you would need to consult a legal expert in order to come up with the proper solution to dealing with your data. I know that this might be frustrating to run into a dead end and not be able to continue, but this is basically what the consent form wizard is supposed to do for you. So it is not only supposed to provide you with a consent form for your purposes, but it is also supposed to tell you if there is a problematic field with regards to data privacy in the research that you're doing. But let's say we are not running into this problematic dead end. In that case, you will have to indicate the purpose of your data collection. And again, you can see that I'm going to speed up a little now, that you will get some more detailed information that provides you with some context for the question that we're asking you. So the purpose of data collection for your research purpose data collection could be research, or it could be something else. If it's not research, then you're in the wrong place and this tool is not for you. If it is research, then you can continue. So now you can add some information about your project. The information that you add in here will directly translate into your consent form, so you will actually receive a fully filled in text with all the necessary information, and you can print out the result and hand it over to your data subjects straight away. So we are calling our research project ABC. And it is, of course, a research project from the digital humanities. And our central research interest is, of course, ABC, as the project name indicates. And then we will also have to provide a project website. And we're going to use this one. Next, it is important to indicate if you are doing research by yourself or on behalf of a research institution, because that will, of course, change the legal status of the data collection that you are carrying out. So if you are actually working for a research institution and implementing your project there, then you are not personally responsible for the data processing, but the institution is. So that makes a difference. We are just filling in blind text in here. Because the tool will not let us continue if we don't fill in the fields properly. So that's very helpful, especially when you're trying to present it. Also, a very important question is if your institution has a data protection officer. If you have one, you will have to indicate name and contact address, because that person is actually responsible in case of any inquiries. If not, you don't have to fill anything in, which is helpful for us right now. The final question that we see now is how long the data will be stored in a non-anonymized form. So we spoke before about anonymized and pseudonymized and not anonymized or pseudonymized data. If data is anonymized, it is not personal data anymore. Therefore, it is not subject to the GDPR. As long as it is not anonymized, it is subject to the GDPR. And you have to indicate how long you're planning to store it. If you're planning to store it indefinitely, if you're planning to archive the data, then that will send you into a dead end again, because that is problematic under the GDPR. So there is, however, a workaround, and you can say that you're planning to store the data for as long as necessary for the fulfillment of the defined research purposes. And so this might be sort of a workaround to even get to the possibility of potentially archiving the data. Data sharing is yet another sensitive area defined by the GDPR. So especially if you're planning to share your data outside of the European Union, there is quite a lot to consider. So you will have to find out if you're if there are legal, Walter, help me, Abkommen. Treaties. Thank you. You know, with the multilingual tool. So if you will actually have to know if there are actually international treaties with the countries that you're planning to share the data with, etc. So this is also an important aspect. Let's say we're not sharing our data so that we can finally come to the end of this demonstration. You will have the chance to review all your answers one final time, and then you can finish. And you will be presented with a proper consent form that you can print out in the way that you find it here and hand over to your research subjects to sign. Of course, this is now formatted in a not so print-friendly way. And of course, if you are working for a research institution, you would probably want your research institution's logo on your consent form, etc. For that case, you can download the raw text, which you can then format in any way that you see fit. And there you go. Here you have your consent form. That's, I would say, the first half of our testing session. So now you know what to do and how the tool works. So I would hand it over to all of you now and give you a chance to test out the consent form wizard, to use it to come up with a consent form for a hypothetical, potential, or even actual research project, or other purpose that you might find it useful for. Test it out, play around a little, and feedback in, what's our plan? In about
so okay, now we will actually
an hour.
Yes, divide the online participants into two breakout rooms. One will be led by Pavel and the other one by Walter. So you can then test the tool on your own, and I think that you can choose whatever language you would like to test. We will prepare the breakout rooms for you. It will be automatically assigned. You just need to type yes or join the room or whatever message pop up on your windows. So we will be back in the joint session at 4:15 after the coffee break. So these online groups will be 1 hour long. That's plenty of time for you to test the tool, even to discuss it with your moderators, and check all the possibilities. You have 3 different scenarios, as you could hear. So you can test all the 3 of them, or you can stick to one of them and check it very in details. And then we will hear your feedback in the next joint session.